3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner. On behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which is being live streamed in order to maintain our open courts requirement. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to argue, and the appellant has reserved some time for rebuttal. Unless there's an announcement, I'll ask Mr. Hibner to call the case.
Michael Charles Smallbone versus Jennifer Elizabeth Smallbone.
Mr. Holloway, you have the floor.
Thank you, Your Honor. Good afternoon. May it please the court. Will Holloway on behalf of the appellant, Michael Smallbone, in this case. And I noted to Mr. Hibner, and I see my time has reserved 5 minutes for rebuttal. This is an appeal stemming from a divorce action in Williamson County. The parties were married 16 years. They have 3 minor children. They had, at the time of trial, a 7-year-old boy and then 2 4-year-old twins. Father's primary challenge on the appeal concerns the parenting schedule that the court outlined in the case. The schedule the court ordered was essentially an equal time parenting plan. The court ordered that father would have 185 days to mother's 180, naming father the primary residential parent. And if, as your honors continue to deliberate and review the parenting plan, you'll see that the actual schedule laid out is an equal time plan. And then as you get into the other section of the parenting plan, there's a provision that says father gets 5 additional days that he can exercise at his discretion. So essentially an equal time plan in this case. This court has addressed equal time plans in the past. I cited in our brief and would ask the court to note the Regendron case that this court issued last year. The Regendron case really restated a ruling from a 2005 case. And Regendron really provides guidance for trial courts as to when it would be appropriate to order an equal time plan. And what the court said in that case is, quote, joint custody arrangements are appropriate in certain limited circumstances. However, while authorized by statute, joint custody arrangements are generally disfavored by the courts of the state due to a realization that such rarely serves the best interest of the child. The court would continue stating in order, quote, in order for a joint custody arrangement to serve the best interest of the child, it requires a harmonious and cooperating relationship between both parents. Then the court goes on to state that there must be direct, specific proof that it's in the child's best interest to divide custody evenly between the parents. And so in this case, we do have essentially an equal time parenting plan, but we do not have a cooperative and harmonious relationship. And I don't believe that is in dispute. The holdings by the trial court, it's a 48-page memorandum, extensive findings of fact and conclusions of law, as the trial judge always does in these types of cases. But it outlines why there's nothing harmonious about this family dynamic, unfortunately. And when the court continues its deliberations and reviews the trial court's findings of fact, I think the court will see that there are serious and significant acts by the mother in this case that cause the equal time parenting plan ordered to be an abuse of discretion. The trial court makes approximately 2 pages of credibility findings against mother. The trial court makes findings that mother has engaged in domestic violence, that she physically assaulted father on 4 separate occasions, including grabbing him by the throat on one occasion. She falsely accused father, according to the findings of the trial court, of committing physical violence, domestic assault on her. She falsely accused father of committing sexual abuse on her. These are all findings by the trial court as to what mother attempted to do. And the trial court found, as it relates to the false allegation of sexual abuse, the trial court found that mother did so in order to intimidate father as it relates to the divorce action. So the trial court makes all of these findings against mother, and it wasn't, the trial court found it wasn't misbehavior directly solely at father. The court found that mother had, quote, explosive anger that had a bursting radius that included the children as well as the husband. The court found mother told the children, daddy is mean to mommy, daddy is a liar, daddy is stupid, daddy is controlling, daddy has a girlfriend. All of these things the court found that mother told the children, and all of those things the court found to be false. On one occasion, while mother was talking to the children about these things, father was present in the room and objected and asked mother not to speak to the children in that manner. Mother's response was that she felt it was a teachable moment for the children. So I feel confident in saying, and I don't believe it would be disputed, that there is some pretty horrific behavior by mother in this case. In the face of these attacks, and I do believe this case is differentiated from the Regendron case that I cited that came out last year. In the face of these attacks in the Regendron, both parents, this court found, shared blame in creating this terrible relationship that existed between the two of them. In this case, that is not true. The trial court found that in this case, father exhibited, quote, commendable restraint and did not reciprocate and did not perpetuate this inappropriate behavior in this terrible environment that was existing for the children. In addition to these acts by the mother, there are other serious and concerning behavior that the trial court noted. One of them had to do with a medical insurance card. Mother provided the children medical insurance through her work. Well, father asked for a copy of the card and mother said, no, I didn't get it. I don't have the card. I can't give you a copy of it. Mother continued with that claim all the way into and during her testimony at trial. She was then thoroughly impeached, as the trial court said, with a photograph showing that the card was in her wallet all along, and she simply wasn't providing it because she didn't want father to be able to provide parenting to the children. So that was another claim. The trial court would go on to say that mother's conduct in that regard, quote, raises serious concerns in the court's mind regarding the reliability of her profession of commitment to co-parenting. There are several other examples in our brief of misbehavior along those lines. There were credibility findings against mother for hiding finances, that she provided false sworn testimony with regards to secret bank accounts, false sworn testimony with regards to a $300,000 retirement account that she did not disclose. And so all of this behavior, and as father was testifying to at trial, all of this behavior contributes to this poor relationship that existed between the parties.
Mr. Holloway, if we agree with you that their working together in joint decision-making is not appropriate, what relief are you seeking?
Sole decision-making, as it relates to the sole decision-making for father with regards to the four major categories. As it relates to the parenting schedule, there's a thorough record in this case. I believe the court could simply issue its own parenting plan, in which case we would ask the court to adopt father's proposed plan.
That's not what happened in the case that you relied on. We send it back for an establishment of a new parenting plan.
I think the court certainly obviously could remand it.
And in fact, the Supreme Court just looked at one of our decisions and said we erred in requiring a 50-50 parenting plan on remand. So that's too restrictive on the trial court. How do we get to this main issue if the court hasn't resolved some of the issues you raised below?
I'm sorry, how do we get to the main issue?
Yeah, I mean, you started off with the parenting plan, but you say later in your brief that the court didn't make ruling on your request for contempt sanctions. I mean, how do we even reach this issue?
Well, I believe the court could, in the sense that it's not a final order.
Right, yeah, precisely. I mean, you say you requested attorney's fees in your closing and the court didn't rule on that. and the court failed to address your unclean hands argument. So why doesn't it just have to go back then for additional findings on that?
Well, the court denied attorney's fees, but it did not address that, and that was the requested sanctions that were sought. It did not address the specific request for sanctions in its ruling.
So are you saying that we can imply maybe that was denied when the court, so we can reach the parenting plan?
I think that's the implication. There are findings, and I would certainly say, and I'm worried about saying this, but if it means that we have to stay under this parenting plan for longer under the remand, if the court determines that that's the necessary step, that it's not a final order.
Well, I mean, that's what my concern is that when you raise those issues, it makes me believe that there needs to be something more done at the trial level than we can do. And if that's the case, I think the only option is to send it back and have the court address those, and then it come back up again.
And this is kind of new territory for me, but I will say, if that is the court's determination and I can waive that claim then on appeal, just so we can deal with the parenting plan faster, I would be thrilled to be able to do that if the court determines it's not.
That would probably be in the children's best interest, I would say.
Right.
All right. Thank you, Mr. Holloway. We'll hear from you on rebuttal. Mr. Glassford.
Thank you, Your Honors. I assume I can be heard. Grant Glassford on behalf of Jennifer Smallbone, the wife. I want to address the Regendron case at the front end of this, and I will state the Regendron case was issued, I think, fall of last year. It was a one-day trial. There were two witnesses. There was the mother and there was the father. The record is very scant in that case. The trial transcript alone is not significant at all. Judge Woodruff listened after a four-day trial to the parties, 3 expert witnesses, 3 teachers that we brought in, that Ms. Smallbone brought in, and about 11 other, what I'm just going to label character witnesses, or witnesses who testified as to mother's parenting plan, her skills as a mother. So the body of evidence weighed by Judge Woodruff was significantly different than the amount of testimony with regard to this case. With the argument that Mr. Holloway points out that they don't have a cooperative and harmonious relationship, it is agreed that in 2017, 2018, they didn't. The court saw these video recordings. The trial court noticed that wife had made 2 substantial changes that had a positive effect on her ability to parent the children. Number 1, she reduced her demands on her time by discontinuing nursing school and finding a more flexible job that allowed her to work from home. Number 2, she obtained mental health therapy for treatment for the general anxiety disorder. So our position, Your Honor, one should not judge this mother's parenting skills based upon a period of time where she was working excessive hours, pulled in different directions, and wasn't receiving the proper medical attention. Judge Woodruff was very attentive to those issues. Teresa,
did all the claims of abuse occur during that same time period? The hitting father with a hairbrush in the car and twisting his injured finger to try to hurt him further. Did it all happen in 17, 18?
No, sir, it didn't, Judge McBride. The finger pull occurred in the 2018 timeframe. The hitting with the hairbrush was about 12 years ago, according to it was a long time ago. There was no incident, and that was before they even had children. Her testimony on it was a little bit different than his, but to answer your question, no. There was one alleged incident of violence back in the 2009. It was long before the trial. I would like to remind the court that with regard to the cooperation between the parties, in my brief on page 44, I go through a series of communications between the parties, text messages between the parties during what I refer to as the ugly period, the 2018. There is back and forth friendly texting between them, even during this summer, that this all ugly period when it happened. And one of the texts, husband says, "I love you," to his wife. So she was in a bad place. She was suffering from some illnesses that weren't being properly addressed. Don Beatty testified to help deal with the anxiety disorder, and Ms. Beatty made clear that my client had 90 sessions. My client followed the recommendations of Dr. Beatty with regard to techniques to manage her anxiety. Teresa Monroe testified, and she's been seeing my client. She prescribes the medications. In my brief, I at length went into what Mr. Monroe's testimony was. It starts on page 5 and thereafter, and also what her medical record showed with regard to my client being compliant with the treatment, being an ideal patient, asking the right questions, being engaged in her therapy. So I believe that made an impact on him, because one of the things he ordered in the parenting plan was that she needs to continue to remain compliant and provide proof. I will point out that when I compare trial exhibit 54, which was husband's proposed parenting plan, versus the parenting plan that was ordered, I want to point out a couple things to the court. Husband asked to be named primary residential parent. Check, he got it. Husband asked that the fall breaks, the even part of fall breaks every year go with him. He got that. Husband asked that Thanksgiving and odd years go with him. He got that. Husband asked that he get the first period of Christmas every year. Check, he received that. Husband asked that he get spring break and odd years. He got that. Husband asked that each parent get 2 weeks of summer parenting time. He didn't quite get that because the judge ordered week to week. He proposed in his parenting plan that my client have 120 days a year. And that's the big difference. That Judge Woodruff ordered week on, week off, basically. Not basically, that's what he did. And he said father would get 5 additional makeup days. So the day count would be 185 to father and 180 to mother. Why did he do that? He did that because it's in the best interest of these children. How do we know it's in the best interest of these children? Well, we know from the actions and deeds of the parties. My client birthed these children. She took time off work. She made the doctor's appointments. There's reference to the pediatrician records and the dozens and dozens of visits my client arranged and went to. She was not dismissive of Mr. Smallbone's contribution. She gave him credit where credit was due. Interestingly, the only compliment he made about his ex-wife during trial was, quote, she's a hard worker, period. During the course of these proceedings, even after the complaint was filed and before, he repeatedly would go out of town on work. He had a law practice and he had a speaker's business, which required extensive travel. Mother was the primary caretaker during all of those times. Even during the ugly period, he left the children alone with mother. They would have a blow up. He would meet his buddies down at, this is in my brief at the end, all the texts back and forth with regard to meeting his friends for pints, a pint of ale, he's from Australia, at Scouts. So we do not run away from, nor do we try to explain away necessarily these videos. But I will tell you, by the actions of the parties, Mr. Smallbone demonstrated his trust in the mother to be able to care for the children. In addition to that, by leaving them with her for extended periods of time. Even while this case was pending for 2 years, the complaint was filed July 6th of 2018. We went to trial 2 years later. What happened in that period of time? Mother took the children, this is in my brief, on trips out of town to Memphis, to Atlanta. The parties had a beach house on 30A, Santa Rosa Beach in Florida on the Gulf Coast. Mother went down there repeatedly with the children alone. Father had no complaints about that. With regard to cooperation between the parties, there's proof in the record that in the May period of 2020, just a few months before trial, there were friendly texts back and forth between the parties to coordinate how they could exchange the children at Santa Rosa Beach. Wife, my client, rearranged her work schedule a few times to accommodate his work schedule. Being a lawyer, testimony reveals that he had deadlines. Deadlines came up. She was aware of that. What did she do? She made arrangements with her employer so that she could accommodate his needs for that trip in May of 2020. They traded the children off in May of 2020. They spent the same night in the condominium in May of 2020. So with all due respect to my worthy adversary counsel, the husband wants to focus this court solely on 2017 and 2018 and ignore the cooperative relationship between the parties, both prior to and during the divorce trial. Yes, there was marital strife. Yes, there was marital conflict. Yes, the judge made findings. The judge, when we finished the trial at July 7th, the judge took it under advisement and issued his memorandum of opinion 6-7 weeks later, August 21 of 2020. He gave careful consideration to these factors. My client's role as a mother and what's in the best interest of these children is really the primary focus here. That's what this case is all about. And she has been a constant in their lives every day. The three school teachers that testified, Pam Horn, Kathleen Stampley, and Victoria Stafford, said she was an ideal mom. She would show up. She was plugged in. She wasn't walking in on her phone texting. She was attentive to
Now, ideal, except, I mean, it seems like to me there was competent testimony here from the therapist that mom's behavior did impact the older child.
Yes, sir, it did.
And it seems like to me that's sort of one of the classic limiting factors under 406. Why does that not work here? Why did that not apply here?
Well, Jay Woodman testified on behalf of father, and Dr. Woodman and his the findings from Dr. Woodman, and he testified to this, that the child's exposure to conflict between the parents is the main contributing factor. Okay, so Dr. Woodman recognized that his exposure to conflict, that has been removed. These parties are no longer living under the same roof. They stayed in the same house until after the trial. Mr. Smallbone moved out after we received the memorandum of opinion. But in the further answer to that question, Judge McBriar, all these video recordings, they had this Nest Cam, and the Nest Cam was going 24/7. Every recording was conflict between mother and father with the children present. That was the common denominator. There was not one video or shred of evidence presented where mother was losing it, was angry, was abusive, was mean to the children without the father present. So when they were in the same space, yes, sir, there was conflict. And without belaboring the point, I think the record was very clear that at the time mother was burning the candle at both ends. She was a full-time student. She was working full-time, that she had to maintain for the benefit of the family to keep the health insurance, because as a solo practitioner, he didn't have any benefits. And it was on her to get health insurance for the children. So she worked to maintain the health insurance. She went to, because that was at risk because of the fact that her cases were slowing up. She wasn't getting the requisite number of hours, and she was concerned, and he was concerned, and they talked about this, and they agreed, go to nursing school. She enrolled in nursing school. She was also, her prescription of the Zoloft had been decreased. Teresa Monroe had recommended 200 milligrams years before. She was taking some diet medication, was contraindication. So we have this.
But the Zoloft was decreased during the period that she was pregnant with the twins, right?
Yes, sir. Right.
So I mean, she should have gone back on. I mean,
she should have, but it didn't happen. And then when she started seeing Teresa Monroe again because of the anxiety, Teresa Monroe testified, hey, I recognize that the Zoloft had gone down to 100 milligrams. Let's put it back up to 200. Okay, so when my client learned that is a possible factor to her anxiety, she was compliant. Her prescribing nurse practitioner, Monroe, up to 200. She took that. And also, it was determined that this diet medication she was on was increasing her anxiety, so she went off of that. But Dr. Woodman was very candid and very credible, and all of the expert witnesses none of them were deemed to be not credible. And Dr. Woodman made it real clear that both parents have done a really good job following what I say. Dr. Woodman said, volunteered, in his waiting room there on 21st Avenue, he's got this room, and the twins, who never have had any issues about that required any kind of counseling, he would go out and visit with the family before he would take Nathaniel back into his private office, or the parents. And he said, quote, there's a lot of good things happening in this family in terms of the children seeking attention in a reasonable way. Those are his words. Okay, that's in my brief. And he said, Dr. Woodman said, in direct response to a question from Judge Woodruff, that he said, Dr. Woodman said, Father has implemented his recommendations. And Judge Woodruff said, okay, let me ask you the same question about Mother. What about her? And he said, yes, sir. She is also following my recommendations. So this ugly period should not define a mother's role in the lives of these children. They need her. They love her. There's testimony from more than a dozen witnesses that talk about the close relationship that mother has with children. Father even admitted that the children love their mother very much. In the middle of trial, on day 2 of trial, one of the children woke up in the middle of the night screaming in fear of terror. One of the twins had a nightmare. The father was living in the house on the same floor as the children. He had vacated the master bedroom where mother was sleeping. And the child, who did he go to? He went to his mommy. He didn't run over to his daddy. He came to his mommy. And that's not an isolated incident. So these children need their mom and they need their dad. And these parties do have a pattern and a track record of having some level of harmonious relationship. And the judge put guardrails in the parenting plan with the counseling, and he ordered the continued treatment with Woodman, Dr. Woodman, or if he's not available, my time is up, another Mercy Community Hospital in Franklin. So the plan in place protects these children. I wish I could keep talking, but I see 0 and I don't want to wear out my welcome. If there's any, unless there's no further questions, man, I'd love questions, but my time's up.
All right. Thank you, Mr. Glassford. Mr. Holloway, rebuttal.
Thank you, Your Honor. The argument that is presented on appeal by wife is, yes, I committed these heinous acts in the past, but that was a year and a half before the trial, and I was not physically abusing my spouse at the time of the trial, and I was not making false allegations of sexual abuse at the time of the trial, and so we should all just move on. Mr. Smallbone, my client, testified about continuing difficulties with wife. And I don't dispute that she stopped with the claims and the physical assaults that she was making before. But that is resetting the playing field by a large margin to say that if you are not doing those things, then you should have an equal time parenting plan. That is clearly not the standard under Tennessee law. What was true and was found by the trial court is that mother's misbehavior. Now, she stopped doing the extreme things. I would submit, coincidentally, at the same time she learned they were on video camera, but she stopped doing the extreme things as they got closer to the trial, but she was still misbehaving. She testified untruthfully on a direct issue relating to the children and withheld that medical insurance card solely to interfere with father's ability to co-parent, and then lied about it at the trial. There are other claims that she made during the trial that were directly untrue and for which there is no explanation, and it certainly cannot be that it had anything to do with her mental health struggles in 2018. So her misbehavior continued. And Dr. Woodman, as Mr. Glassford referenced, Dr. Woodman expressed an opinion to the trial court on what would happen in this case under an equal time plan. And that's the other part of the Regendron opinion, is that there has to be specific direct proof that an equal time plan is in the best interest of the children. We don't have that, but we do have Dr. Woodman saying the opposite. And the court quoted Dr. Woodman in its opinion, and that Dr. Woodman expressed his opinion that as parenting time approaches equal sharing, there's a greater need for the parents to cooperate with each other. And Dr. Woodman said that an equal time plan in this case will generate heightened conflict between the parties. the court notes that, and then the trial court makes its one finding of fact that is negative about father. The court says of the court's greater concern is that father is pessimistic with regards to his being able to co-parent with mother in the future. Yeah, the poor guy has been accused falsely of domestic violence. He's a practicing attorney, has been falsely accused of domestic violence and sexual assault. And now the trial court has ruled that he is inappropriately pessimistic as it relates to his ability to co-parent. Mr. Glassford correctly points out all of these cooperative and good communications between the parties. But what the result is, if the court says we have to maintain this equal time parenting plan because in spite of all of mother's ridiculous claims, father has continued to be a good parent. Well, that is just forcing father to be in this impossible situation because he did exactly what the law asks him to do. He rose above it. He cared about the children above the divorce bickering. He is the exception, unfortunately, to what we see all the times in these cases. And at the end of the day, what he has now is an equal time plan with somebody that he cannot co-parent with. And so I would ask the court as it continues to look at the record, and I do think as Judge McBrayer touched on, the timeline is important, and the court will see that there's not an exact mesh between when mother allegedly has this epiphany through her mental health treatment that lines up with her behavior in this case. So I'm running out of time. I thank your honors for listening and thank you for your deliberations moving forward in this case.
Thank you, Mr. Holloway and Mr. Glassford, for your arguments. You've given us a lot to think about. We'll take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 2 p.m.
Thank you. And counsel, you're free to exit the meeting.
Thank you, Judge.